In this tutorial, we will be covering company accounts, which will include what they are, what information needs to be included, and how to interpret them. Before we proceed, however, it must be noted limitations are placed on solicitors by the Financial Services and Markets Act 2000 when providing financial advice. Solicitors must bear these regulatory limitations in mind when providing such advice to clients. All limited and unlimited companies, regardless of whether they are trading or not, must keep adequate records which show and explain the company's transactions, disclose with reasonable accuracy the financial position of the company at that time, and enable the directors to ensure that any accounts required to be prepared comply with the requirements of the Companies Act 2006. In particular, accounting records must contain entries of all sums of money received and expended by the company, together with a record of the assets and liabilities of the company. It's a fundamental notion of company law that information about a company's financial status should always be made available to the public. The motivation behind such openness is to ensure that anyone interested in the affairs of a company, whether that happens to be a prospective or current shareholder in the company, or its creditors, can have access to the information they need to make an informed assessment of the company's financial affairs and management.